But it's not a bad day. Still better than the UK. I believe we are live now. Good afternoon, everybody. I'm Sasha Muller, the convener of the ANC Progressive Business Forum. I'm honored today to be the facilitator of today's event. I'd like to welcome our very special guest today, Deputy Minister of Justice and Constitutional Development, John Jeffrey. You won't be seeing his video right now, but you might when you will when he is speaking. We also have our legal partners, Ms. Savannah Kanzler with us from Bissett Boomka McBlain Attorneys. Now, a little interesting fact around that is that I believe Bissett is one of the oldest law firms in the country, if I'm not mistaken, Savannah. 1853 or something like that you were established. Is that correct?
I think so, yes. That is what, as far as I know.
Well, that means that you guys certainly have paid your dues, and we can certainly trust in the input that you'll be giving us today. And then, of course, a very special welcome to our PBF subscribers, to you with us here today. Before we begin, allow me to make just a few remarks and a background around the context of today's event, just to provide you some guidance around the running order and procedure we will follow. We aim for this event, if you want to set your times, to latest end by 4:30. We understand it's a Friday and people want to get home. But this is a very important content we're talking about. Deputy Minister Jeffrey, as one of the principal architects of the Protection of Private Information Act, Popia, will give us a background and motivation around its framing and of its effects and implications. Now, I believe, Minister, you were very involved in the process of putting this together, so we're very eager to hear from you about this. Savannah Kanzler from Bissett will talk to us about the practical implications and how the application of Popia will affect your business. So this will then move from something that is as in conceptual and an act into how you can look at implementing it into your business. We will then follow with remarks of questions from you as a subscriber, and we will make sure there's enough time for you to have good discussion and engagement. Often we find in webinars, people leave questions right to the end for 3 minutes. We will make sure there's enough time that we will try and hear as many of the questions as possible. Please, if during the engagements you have questions or if you have comments, please post it in the speaker note in comments and in the chat box. I will then address it and facilitate it to the minister. If you would like, or to Savannah, if you would like to ask a question yourself, we will open the platform for that. Please raise your hand. There's a raise the hand button, and we will then allow you the opportunity to speak directly. For any new attendees today, while most of you probably know the PBF, it is important to remind us once more of the following. The PBF is a program of the ANC, and under the authority of the ANC Treasurer General, Comrade Paul Mashatile, it is mandated to promote and enhance liaison between government, the ANC, and business. The PBF, with its focus of empowering SMMEs, runs several programs, and in the terms of our mandate, includes ministerial briefings, research and roundtable discussions, business summits, skills training, development workshops, trade exhibitions, trade facilitation, and our progressive women in business summits, among others. Subscribers would have seen that the PBF is increasingly making use of online and digital platforms. In fact, coming in January this year, we'll be launching our own platform, which will be a very unique platform of engagement, making us more accountable, transparent, and effective in the way we communicate in the course, creating a better social compact between all of us. And of course, ensuring that the subscriber finds the PBF at the center of excellence, trusting to ensure that your voice is heard at the highest level and also understood. So I encourage you to reach out to the PBF and to be actively involved with us. The PBF program of action is designed for you, and it delivers and works best with your active participation. As part of our offerings to our subscribers, the PBF conducts ministerial briefings and discussions on issues of relevance to business. Today is exactly one of them. And the subject of today's meeting is the Protection of Private Information Act, Popia. It holds significant relevance to business and indeed to all of us, even as individuals. Based on Section 14 of the Constitution, the right to privacy, Popia was designed to prevent the misuse of personal information of citizens by anyone who uses such details of private citizens, including for direct marketing, unless the specific and explicit permission of the person concerned is obtained. Now, we've all in our lifetime received those call center calls, and we're wondering where on earth did they get our phone numbers from? This, moving forward, will no longer be allowed. Among other things, the Act provides guidance and definition on what is considered personal information and establishes conditions under which personal information may legally be gathered and processed. It was signed in 2013 by former President Zuma. Only parts of the act came into force at that stage. The effective enforcing agency of Popia is the Information Regulator. It is headed by Advocate Pansy Takulu. When the act is fully enforceable, there will be significant penalties for the breach of the act. This, of course, has an impact of you as a business. President Ramaphosa's statement in June 2020 makes further parts of the act enforceable from the 1st of July this year, which gives parties and companies 12 months to be fully compliant. And in other words, that means we have until the 1st of July 2021. After this short introduction of mine, I will hand over directly to the Deputy Minister, who will then speak about Popia. From there, I will then facilitate the transfer over to Ms. Savannah Chancellor, and then after that, open the floor to you as the subscriber. Thank you very much for joining us today, and we do hope that this will be an informative session. Without further ado, I hand over to you, Minister.
Thanks very much, and good afternoon, everybody. Just some apologies. I'm in a car, so before the end of the event, I will have reached my destination, and you should have a better background picture or a better view of me. But thanks very much for the opportunity to engage. Access to information is globally recognized as being crucial to transparency and to good governance. In our constitutional democracy, accountability and transparency form the basis of good governance. Information is fundamental in achieving these goals and incapacitating persons to exercise their constitutional rights. The right of access to information is vital in order to create the transparency necessary to hold both government and the private sector actors accountable. Before South Africa became a constitutional democracy with a justiciable Bill of Rights, the system of government in South Africa resulted in secretive and unresponsive culture in both public and private bodies, which often led to the abuse of power and human rights violations. The old apartheid state made sure it only allowed us as citizens to know what they wanted us to know. The culture of secrecy meant that many human rights violations never saw the light of day. They were covered up and swept under the carpet. The more secrets the state kept, the more wrongs, the more It's against this backdrop of our history that the Bill of Rights in the Constitution provides for the right of access to information held by the state and any information held by another person that is required for the exercise or protection of any rights. Section 32 of our Constitution provides for the enactment of national legislation that will give effect to this right by respecting, promoting, protecting, and fulfilling this right. The Promotion of Access to Information, Act 2 of 2000, or PAIA as we call it, is the national legislation which was enacted to give effect to the Constitution
I do apologize, subscribers. Sometimes we're moving in and out of hearing him. I think what's happening is due to the traveling, he may be coming in and out. Can I just confirm, Seth?
Yeah, hi, Sasha.
Is he still, has he dropped out?
No, not yet.
My apologies, subscribers. There we go. He's out.
Hi, sorry, you missed me. I lost you. So I was just saying about the value, how valuable personal information is. And as it's so valuable, it means it needs to be protected and handled with care. The Protection of Personal Information Act was passed in 2013 and put into operation in stages. In the preamble, it states that there's a need to regulate, in harmony with international standards, the processing of personal information by public and private bodies in a manner that gives effect to the right to privacy, subject to justifiable limitations that are aimed at protecting others' rights and important interests. The aim of the legislation is to protect persons' personal information so that people do not become victims of crimes such as identity theft or other data breaches. It also relates to aspects such as direct marketing and how businesses and other institutions must deal with any personal information they have in their possession. In short, the Act seeks to give effect to Section 14 of the Constitution, which provides that everyone has the right to privacy. The Act promotes the protection of personal information processed by both public and private bodies and seeks to balance the right to privacy against other rights, such as access to information. As you know, a number of sections of the Act were already implemented. In April 2014, these sections included those relating to the establishment of the Information Regulator. The members of the Information Regulator took office on the 1st of December 2016, and Advocate Pansy Tlakula is the chairperson of the Information Regulator. Many of the remaining provisions of the Act could only be put into operation at a later stage, as they required a state of operational readiness for the Information Regulator to assume its powers, functions, and duties in terms of the Act. In view thereof, the commencement of a number of the remaining sections were proclaimed by President Ramaphosa. The relevant sections and applicable dates were as follows. Basically, all the rest of the Act came into effect on the 1st of July this year. And then sections 110 and 114.4 commence on the 30th of June next year. The sections which commenced on the 1st of July are the essential parts of the Act and comprise sections which pertain to, amongst others, the conditions for the lawful processing of personal information, the prohibition of the processing of special personal information, codes of conduct, procedures for dealing with complaints, provisions regulating direct marketing by means of unsolicited electronic communication, and the general enforcement of the Act. Section 114.1 is of particular importance, as it states that all forms of processing of personal information must, within 1 year after the commencement of this section, be made to conform with the Act. This means that entities, both in the private and public bodies, will have to ensure compliance with the Act by the 1st of July next year. The two sections that haven't come into effect, those that come into effect on the 30th of June, are sections that pertain to the amendment of laws and the effective transfer of the functions of the Promotion of Access to Information Act, PAIA, from the South African Human Rights Commission to the Information Regulator. In this regard, the Commission must finalize or conclude its functions referred to in PAIA, and all mechanisms must be in place for the regulator to take over these functions. The reason for the 1 year delay was a view that the Act needed to be fully in effect for those sections to come in, so that all the remedies in PAIA, or the new remedies in terms of PAIA, continue. So what does this mean for business, and what will they have to do in order to ensure that they comply with the legislation? Media reports from August this year state that IBM Security announced the results of a study examining the financial impact of data breaches, revealing that these incidents cost South African companies an average of 40 million rand per breach. The study found that malicious attacks on customer, employee, and corporate data were most prevalent, accounting for 48% of incidents and proving to be the costliest cause of breaches to businesses. And many companies, particularly SMMEs, may be tempted to think they don't really have that much personal information of clients within their control. But as Professor Rebecca Herold, better known as the privacy professor, says, and I quote, "Consider this: if you have 100 employees and they each use an average of 2 smart devices within your business processing environment, you've just created at least another 200 data storage areas. And in all the third parties that are getting copies of the data, and that number exponentially increases. How can organizations safeguard and control all that data in all those other unknown storage areas? This opens up the organization to many additional security, privacy, and legal risks." Close quote. So, ladies and gentlemen, all of us receive direct marketing calls, usually on a daily basis. People may be existing clients of company A, only to later get a host of unsolicited spam calls or emails from companies B, C, and D, offering them all sorts of goods and offers because company A shared their personal details and information with companies B, C, and D. In this regard, when it comes to direct marketing, it's important to note that the Act follows an opt-in approach. In other words, consumers and clients deemed to have opted out of receiving communications via direct marketing unless they've expressly opted in. And the reason for that is, the current system under the Electronic Communications Act is opt out. If you don't want to receive communications anymore, or send an email, send an SMS. For many people, including myself, I don't know which database my contact information came from and whether they in fact know that there's a real person at the end of it confirming or receiving this stuff. And if I opt out, then somebody's going to know that this email address or this phone number is real. And so I don't like opting out. Anyway, it will now become opt-in. In an interview earlier this year, Advocate Pansy Tlakula, the chair of the regulator, is quoted as saying that the Act will provide protection from unsolicited telemarketers, but she did warn that information posted online on social media will remain in the public domain. In short, entities which process personal information must ensure that it's done in a lawful way. Section 11 of the Act is very specific. Personal information may only be processed if, firstly, the data subject or a competent person, where the data subject is a child, consents to the processing. Secondly, the processing is necessary to carry out actions for the conclusion or performance of a contract to which the data subject is party. Thirdly, processing complies with an obligation imposed by law on the responsible party. I think we're on fourthly, processing protects the legitimate interest of the data subject. Fifthly, processing is necessary for the proper performance of a public law duty of a public body. And lastly, processing is necessary for pursuing the legitimate interests of the responsible party or of a third party to whom the information is supplied. The Act applies to any person or entity who keeps any type of records relating to personal information, unless the records are subject to other legislation which is more stringent. In other words, the Act creates a minimum standard for the protection of personal information. So what exactly is personal information? Personal information has been defined broadly and means any information relating to an identifiable living natural person, as well as an identifiable existing juristic person. In other words, an entity or institution, including but not limited to information relating to race, gender, sex, pregnancy, marital status, national, ethnic, or social origin, color, sexual orientation, age, physical or mental health, well-being, disability, religion, conscience, belief, culture, language, and birth of the person. It also includes information relating to the education or the medical, financial, criminal, or employment history of the person, and any identifying number, symbol, email address, physical address, telephone number, location information, online identifier, or any other particular assignment to that person. It also refers to the biometric information of the personal opinions, views, or preferences of the person, and correspondence sent by the person that is implicitly or explicitly of a private or confidential nature, or further correspondence that would reveal the contents of the original correspondence. Even the views or opinions of another individual about the person and the name of the person if it appears with other personal information relating to the person, or if the disclosure of the name itself would reveal information about that person, would be regarded as personal information. A responsible party means a public or private body or any other person which alone or in conjunction with others determines the purpose of and the means of processing personal information. So in short, businesses must have adequate security measures when dealing with someone's private information and exercise caution and discretion in dealing with that information. They have to manage their databases and keep records of how and when they obtained a person's personal information and whether or not a person has consented to receiving direct marketing. The Act is fundamental in safeguarding persons' personal information and thus protecting them against data breaches and theft of personal information. The Act gives strong enforcement powers to the information regulator, such as imposing fines of over 10 million rand and referring matters for criminal prosecution. And let me just state that the way the Act is structured, it is not a criminalization act. It doesn't create crimes. It sets out the conditions for processing personal information. And if there is a complaint that information is not being processed accordingly, you then have to complain to the regulator. The regulator will investigate. And if they find in your favor, they will issue an enforcement order, which the other party will have to comply with. And if they don't, then that other party becomes liable for criminal action. So the criminalization is something that comes later. It's not immediately upfront. The only crime in the direct crime in the Popia is processing personal bank accounts. And that was basically because, and my role in Popia was chairing a technical committee in the Portfolio Committee of Justice that was going through and amending the bill that was introduced. And we'd had too many cases of people who, their bank account details had been sold, made accessible to businesses. They would have telemarketers phoning them, asking them if they wanted the service. They would often say they didn't. And then they would find their accounts were being debited because the people had their account details already. So that criminalization is in effect already of processing people's personal bank account details. So in other words, if you sell a database of somebody's bank account details, you have committed a crime. So Popia affects every business or company that is in possession of a person's personal information and how they use that information. And so what happens if you have a data breach? It's vital that the information regulator be informed. The regulators designed and maintained a data brief register to enable responsible parties to report any security compromise, such as a data breach, and has continuously advocated for proactive compliance by responsible parties with the provision of Popia. As we move forward towards the implementation of the Act, it's vital to remember that data is a currency of its own. Treat it in the same way as you would treat money. Ultimately, the Act is there for our protection, but it can only do that if we proactively put the necessary steps in place. Thank you.
Thank you so much, Minister. Sure, that's is a lot of input there. And what was interesting to me is there was this recent data breach of Experian And it'll be interesting to know how, if others have gotten hold of that information now, because I mean, that's everyone in South Africa's information, and they use it, how would you be able to measure that? Because once someone has that information, how can you manage it? How can you control it? Also, those contact and service centers who, as you say, at the moment, it's an opt-out. If I'm already sitting on maybe 50 databases as a person, I'm unaware of it. In 30th of June 2021, does that mean they can no longer have me on that database? Or does that mean that I can stay on, but I still have to opt out, that I'm considered on it? So I guess it's just the semantics of it, but we will delve into that a little bit later.
Do you want me to answer that or not?
Yeah, if you could, that would be great.
Okay. Look, the way it works with direct marketing is that you can be contacted once. Sorry, let me do that. Sorry. You can be contacted once. So a direct marketer can approach you. So you're not going to avoid the annoying calls. I must say, I think the thing I get most offended by are the calls from a machine. We get this recorded message, and I sort of think, but can't they even have a real person to call me? But anyway, you can, those will still happen. Okay. However, they cannot then call you again unless you have opted in.
Oh, I see.
So it doesn't matter if you're on all those databases, they can call you once, but unless you indicate to them that I want further calls, that's it.
Oh, I see. So
that's how it's intended to work.
Joining us today. Okay, well, that makes sense. But I mean, that can only happen so many times before that's exhausted in a sense.
Well, if somebody like sends you 2 emails trying to sell you stuff, and I mean, obviously not at the same time, but then that they would be reported to the information regulator, who would issue an enforcement notice to say that they must stop doing this. And if they continue doing it, then they will be in breach and can be penalized.
Oh, understand. And they'd have to prove some sort of mandate, which...
They'd have to show that you opted in, yes.
Okay, understood. Thank you very much, Minister. With that, I'll hand over to Savannah. Let's look how what is the practical implication of this for the businesses that have joined us today. Just so everybody knows, Savannah's having issues with her camera today, so we won't be able to see her, but we will be able to see her presentation. Thank you, Savannah.
Good afternoon, attendees. Thank you, Sasha. Thank you, Minister, for that interesting overview. I think much of what I'm going to speak to now will be a reiteration of the points that you made. As has been said, Popia is an act that's intended to protect and give effect to our individual right, our constitutional right to privacy. And the minister listed all the personal information that Popia covers, and as I'm sure you heard, it's quite extensive. But what I'm going to speak to today is more of a practical understanding of what Popia may mean for you and your business. So in understanding Popia, it's important to understand 3 parties. The first that the minister spoke about quite in depth is the information regulator, and they're a body that's been established, and they will be the enforcement mechanism in Popia. They'll receive complaints from the public and investigate whether Popia has been complied with in the circumstances. The other 2 relevant parties are the responsible party and the data subject. And the responsible party would be the business collecting and processing personal information, and the data subject would be the individual that gives their personal information to be processed. Let me just catch up on my slides. So there we've got the three parties. As the minister also mentioned, the way that Popia is laid out is that it creates what it terms conditions for compliance with Popia. And these can basically be understood as different requirements that need to be met when you are processing personal information. Another sort of point to make at the outset is the very broad definition that is given to processing in the Act. So basically, if your business handles personal information in any way, if it involves collecting, using, disseminating, or destroying personal information, that falls under the definition of processing, and Popia will apply to you. So as you can see, I've got the conditions or requirements listed on the screen, but the most important thing to note there is that it's the business, the responsible party, that is accountable for making sure that these requirements and conditions are met. So, what does this mean for a business in practice? As the minister also said, and the first important thing to note is the date of 1 July 2021, because this is the date when businesses need to have their affairs in order and they need to make sure that they are compliant with Popia. It is the end of the grace period on 1 July 2021. The main recommendation that I would make for Popia compliance is to draw up what I've called a Popia plan. And as you can see on the slides, I've got a rough idea of what a plan like that would entail. But it's important to note that Popia is formulated in quite broad terms. So in order to, if you're unsure about how your specific business will become Popia compliant, I think it's important to obtain tailor-made advice, because the Act is formulated quite broadly, and it may apply in different ways depending on how you're using the data and for what purpose. Nevertheless, a Popia plan would essentially involve an explanation of how the personal data, the personal information that your business processes flows through your business. And at each stage of this flow, your Popia plan will lay out how Popia is complied with at that stage. So in the beginning, you will be collecting personal information. And at that stage in your Popia plan, it's important to lay out the purpose for which the information is being collected. Popia specifies or specifically states that the purpose needs to be specific and explicitly defined, and that this purpose for collection needs to be related to a function of your business. So your Popia plan will lay out that purpose and the relative function. The next step that the minister also spoke to is that you need to be legally entitled to collect this information. And there's a number of different ways that the Act outlines when you would be empowered to collect. But the main one would be if consent is obtained from the data subject. So the next step in your Popia plan would outline how your business goes about obtaining this consent. And the Act is also clear that the consent obtained from a data subject needs to be specific and informed consent. So your Popia plan will lay out how you as a business inform the data subject of the purpose that you've already refined and how it relates to the function, and then how they go about obtaining this consent. And the consent needs to be in writing. Once you've collected this information, the next stage would presumably be it being used within the functioning of your business or being stored by your business. And at that stage in the flow, your Popia plan needs to lay out what mechanisms are in place to ensure that that data is secured and that no third parties have access to the personal information that they have now collected. And the next stage in your Popia plan links to this laying out of security steps, in that you want to include in your plan processes that you have in place that test those security measures, so that you are constantly assessing your security, the security of the personal information for potential loopholes or for security risks, and you're addressing those security risks. So you've collected the personal information for a specific purpose, you've obtained informed written consent, you are using the data or storing the data and it's secure. And then the final stage in your plan would be an explanation of how your business identifies when the purpose that the information has been collected for has been fulfilled, and how it then goes about destroying the personal information. So your Popia plan basically outlines, as the information moves through your business, what steps the business is taking to ensure compliance. A final thing to note in terms of the plan is that you want to list which people, which employees will have access to the personal information as it moves through your business. Because this is something that you might be, as a business, you might be called on to account to. Another practical step that links to drawing up a Popia plan is to hold annual Popia training for your staff. Now, this training would basically include making sure that your employees understand that the business has a Popia plan and what the Popia plan says, so that the individuals that are a part of handling and processing an individual's personal information understand their obligations in terms of Popia and the Popia plan, so that they make informed decisions. And then a third practical consequence that the minister spoke to, so I'm not really going to address, is the emails and direct marketing. And like the minister said, there's a distinct line being drawn from the past practice of opting out. And now what is required is that you get consent, you get that opt-in from the individual before you engage in direct marketing with them. And in these emails, you need to include an unsubscribe button and details about who you are as the sender of these emails. And then finally, a note about enforcement. The enforcement procedures that Popia lays out are quite complex, so I'm just going to speak very briefly about that. But if one of the conditions that we spoke about earlier are breached, a complaint can be made to the information regulator, and the information regulator has the decision lays with the information regulator on how to proceed with this complaint. Now, one of the courses of action they can take is to give a responsible party, so a business that has had a complaint about it, an information notice. And an information notice basically requires that the responsible party account to the information regulator on how they comply with Popia. So this is where having a Popia plan drawn up would be very beneficial, because your Popia plan lays out in what ways you are involved in the processing of personal information and how at each stage of that processing you comply with Popia. Another course of action that the information regulator can take is to hand the matter to an enforcement committee, which will then make a recommendation as to a sanction, which is something the minister also spoke about. And there's the possibility of a fine or of imprisonment, and also a civil claim for damages, either by the information regulator or by the data subject against the responsible party that has failed to comply with Popia. So in conclusion, I think that it is recommended that businesses obtain a tailor-made solution for their Popia compliance, because how businesses handle personal information is so different in different industries and sectors. But this sort of general approach of ensuring that at each stage of handling the information, Popia is complied with is the recommended approach. Thank you very much for your time, and I hope you found that interesting.
Thank you very much, Savannah. Sure, it seems quite complex, and a lot of it hangs around the Popia plan. I know I've been working with the PBF on creating our own Popia plan, and I know it took quite a lot of time in putting together, and I'm sure, I hope that many businesses joining us here today know about it. I was wondering around, Savannah, it says you need to do training annually. Is there some sort of training expert that one has to use, or is this just internal training? What designates training?
So the Act doesn't require the training. I put that in as a recommendation so that it forms part of your Popia plan, so that when you're called upon, if you're called upon to account to the information regulator, you need to be able to explain that all the individuals that are involved in the processing of personal information are aware of what they're required to do in terms of the Act. So a kind of training, or at least an internal working through of the Popia plan that the business has adopted, I think is necessary. But it's not as of yet, it's not specifically provided for or in-depthly legislated, if I can say that.
Oh, very much. I have quite a few questions here, so this has sparked a lot of interest, I can see. Minister, the first question is directed to you. It comes across as admin manager at the moment. The question is the information regulator itself ready and compliant as regard to record keeping and IT systems and safeguards?
I would hope they are. I mean, I don't think they have much personal information, but they would have some, and obviously they need to be the leaders in ensuring compliance. So I hope that they would be. Let me also just say, because it's a point that Savannah didn't touch on, and that is that the Act also talks about codes, and the regulator can issue codes of conduct, which basically at section 60. So that the idea of these codes is that for a particular sector, the regulator will issue a code setting out the obligations for the processing of personal information in that sector. And the idea is to sort of make it easier to sort of hone things for that particular sector. And what they've done is they did some draft guidelines for the code, which were put out for public to publish before the end of the year or early next year. And then the different sectors would be expected to engage in developing a code for that sector as to how personal information should be processed. So I just sort of wanted to add that to that point. I think I've answered the question of their compliance. I would assume that they are. I'm not representing the regulator, so I can't speak on their behalf. Thanks.
Thank you, Minister. It just so this public remarks, or rather public response to the draft codes, it's still open for businesses at the moment to to respond to the.
No, what they've done is to, at the start of the process, is they've been working on a guideline for the codes.
Okay.
So it's that guideline that was put out for comment. The idea of that guideline is it'll make it easier for the different sectors to develop codes. And they've put it out for comment. That's closed. They're then taking on board the comments, and they will then be issuing that guideline, as I said, later this year or early next year. And thereafter, the codes will then be developed. So it's a two-part process, and definitely anyone involved in a particular sector really needs to be involved in the development of that code so that it is something that is practical.
Thank you, Minister. The PBF will endeavour to see how we can get the various information and how, depending on the sector that you're in as a business, we can assist in finding how you can contribute towards the building of this code if it hasn't closed already. I have some other questions here. Savannah, how do you believe this can affect the marketing industry? So how will the Popia affect the marketing industry, and what implication does it have?
I think it will have quite a, this is the difficulty with Popia, is that it is quite broad, and there's a lot of parts of it that I think are going to become more clear as we work with it as a society, as it comes into operation and we test the provisions and codes, like the minister mentioned, codes are produced for certain sectors. But I think even just from, like we've mentioned, from an electronic marketing point of view, the shift from opting in to opting out, it's a big change. The focus is now on consent. So marketing agencies need to ensure that when their strategies are based on obtaining or using people's personal information, that it's centered around consent.
Okay. And I assume that this will be extended to the big companies like a Google, who has an awful lot of information of us already, just sitting there, and they use that for marketing, for digital marketing. But I believe digital marketing is Popia compliant, if I'm not mistaken.
Yes, so it will apply to big companies like Google. And it's actually interesting, our Popia Act is quite similar to the Personal Information Acts that, for example, the UK has and the EU. So I think that kind of cohesion is something that we should all, on a global scale, work towards, because there are these massive corporations that are multinational. But yes, from a South African perspective, it would.
GDR, if I'm not mistaken, which is the European version of Popia. Am I right?
Sorry, I think you cut out there.
I'm saying, is what you're returning for the equivalent in Europe is GDR?
Yes, I think so.
Minister, we have one more question here. Is it true you need to get specific approval from a data subject to be contacted if you change what you first got agreement for? In other words, permission is granted to be contacted for passing on information about goods of a company, but I want to contact them to sell other sorts of goods. Does one need specific approval for that?
Okay, as you can tell, I've now arrived, so I'm now safely connected to Wi-Fi and no longer moving. So apologies for that. Look, Savannah may know better, but my gut feeling is that you give permission for the processing of specific information. And if there's any change, if somebody wants to, the responsible party wants to process different information, they've got to get your permission for that information. I don't know if that answers it. So if you've given permission for a particular type of information of yours to be processed, it's only for that type of information. If they want to process other stuff, they've got to get your permission again.
And if, Savannah, maybe you could explain on that. What if, for example, someone's selling hygiene products and they start selling nuts and bolts? Do they need to ask for the information again if they are the person?
I see what you mean. If you decide, you're talking now about with direct marketing,
yes.
that you got permission. Well, I think they should. I mean, my gut feeling would be that what they should do when they get people to opt in is to basically opt into receiving any marketing from that person, if you see what I mean. So yeah. I'd misunderstood the question. I thought it was the data subjects, the requirement of consent from the data subject for processing their information. And obviously you consent not to all your information, but to that specific information that to supply your email address, your date of birth, that kind of stuff. But if the responsible party processing the information wants to process something else, they must ask your permission for that. But with direct marketing, and I'm a little bit surprised that the direct marketing seems to be the main interest, or so many of the questions. But with direct marketing, I would have thought that the provisions of the opt-in should be wide enough. I mean, people can define what that is and that you receive any information from that person.
I think we have quite a few SMEs with us today, Minister. I can see in one of the other questions here is, since there are thousands of SMEs in South Africa, we make our money from hand to mouth by advertising via a WhatsApp group in our community area or spaza shop. Will implementation of all the onerous prescripts of Popia, such as IT and data records and safeguarding alone, be possible for such a small business? It seems like they feel like it's a lot for them to do.
Yeah, look, I think that's where the code would come in. So really, probably there needs to be a code for SMMEs, setting out what they can do, what they cannot do as far as advertising. We may also, I mean, this act is 2013. We did look, well, in fact, the Portfolio Committee, Justice Portfolio Committee, went to the United Kingdom for a study trip on protection of personal information. We also did make we're quite behind as South Africa on this. The EU had already made set out processes. They were then refining these for the current processes that they've set out, and we were able to try and make it compliant. But I mean, technology develops very fast, and one of the thorny issues, there was something, I don't know if people know of it anymore, whether it's still there, but there was an app called Mixit, which young people, kids particularly, would use. And we wanted, there are specific, it's more onerous to process children's personal information. And there's also the requirement of children, their parents giving consent. So at the time, we spent many hours of meetings discussing how do we handle Mixit. And in the end, we sort of left it up to the regulator. Now, Mixit is not an issue anymore. At the time we were dealing with the bill, I think that WhatsApp, or WhatsApp groups at least, didn't exist. So yes, we will probably need to amend. Sorry?
It doesn't exist. You can't find it on the App Store anymore.
Mixit. Okay,
Yeah.
all right. Do you remember it though?
I remember it, yeah, and I remember it being a big thing, and it's just quite interesting how quickly things change.
And that took many hours discussion in the committee of how do you allow Mixit to work without compromising the rights of the children. Wasted discussion then, it seems.
And that's actually a very interesting point, Minister, is that Popia is such an important factor, but when you're dealing with things like this digital innovation, things are changing so quickly, you can't legislate quick enough to catch up with it. I mean, I guess regulations and these guidelines are going to need to be updated quite often to be able to keep up to date with as things change.
Yeah, but that's also why Popia is not so much rules-based, because we knew this was a moving target. You've got the conditions for processing of personal information. So they're broad conditions, and we didn't specify that Mixit must do A, B, C, and D. It's the broader conditions. The regulator will then interpret that and enforce that. So hence the issue of, we didn't set up in Popia to set out a set of rules that people must comply with. We set out guides, and the act is really built to allow for change. Hence the codes of conduct. So I think with the concern of many people running SMMEs, look, the direct marketing aspect is that it's often not SMMEs that are doing direct marketing. It's the bigger companies. I got a SMS, I think it was, or it could have been a WhatsApp message from a very large estate agent, multinational estate agent, wanting to sell me stuff or advise me about things. And I sent them a rather snotty response saying, I wish you would be Popia compliant and stop sending this to me. Now, those are the people that one wants to look at. Yes, people who are looking at creative ways of marketing themselves. It wasn't the intention to penalize them.
So there is still space for creativity in marketing. The marketing industry is dead after this. I think in the media, you sort of see this doom and gloom, oh, Popia is going to kill business. And it's not really, if by what you've said today and what Savannah's explained today, it's clear it's not there to kill business. It's just really about setting out how information is used, and that it's done in the right approach, because personal information belongs to the person. And I think we all need to respect that. And I think it's a great law, and it's an important law for South Africa. It's our constitutional right. And it opens up more space for marketing to be more interesting. So for South Africa, being one of the biggest award-winning when it comes to the Cannes Lions and advertising and marketing specialists, it's going to be interesting to see where the avenue could move next for us with that as well. I've just opened up now for any closing remarks. Minister, do you have any closing remarks?
Look, I hope people found this useful. There's a lot of work that still needs to be done by the regulator in developing guides and things like that. I do know, I think that they had, I think, developed the requirements for opting in, and I have heard that there are complaints from people that those are rather onerous. If need be, we would need to engage with them over that, because the idea is basically we want to ensure that people's personal information is protected, but we don't want to prevent or kill business, basically. I think the other aspect is that with data breaches, you have to notify the regulator. You also have to notify the subject that their data has been breached. So this thing of, in the past, there can be this huge hack on a financial institution and a whole lot of data, personal information is leaked out and you never know about it. That's gone, that's past, that's history. And that's only fair on the subjects. The cybercrime bill is on its last path in Parliament. It was passed before the elections by the National Assembly. It was amended by the National Council of Provinces. The Justice Committee accepted the NCOP amendments and they have approved the bill. It goes to the National Assembly for plenary, I think, in the first week of December. Then it will go to the President for assent. And that deals more with the criminal aspect of data breaches. So if you intercept or things like that, that's criminalized and it should be easier to enforce. So that in a sense goes along with Popia, but Popia, as I said, was not meant to be a criminalizing law. It was meant to be an enabling, developing law. So let me leave it like that. But if need be, we can have further engagements on these issues again.
Thank you, Minister. And the Cybercrime Act is a very important one. I personally know people who have struggled trying to manage issues where they've been a victim of cybercrime, and it's been very hard to sort of catch the people who've done it with them, even though they had them right there. So I think that's going to make a big difference. Savannah, would you like to add anything to that?
I don't really have much to add, other than that this really is an act. It's not something people need to be afraid of as much as it should be celebrated as a way to protect our constitutional rights. I think we're moving into an age, like we've discussed, where technology is moving so fast, and we need to work with the information regulator to ensure that we are protected in the best way possible. And it will be interesting to see how Poppy and the information regulator refines what we've got in the starting block here into something that's workable in business, in practice, but also to protect.
Thank you, Savannah. And I think great point there. It's nothing to be afraid of. And working with the information regulator, I think business need not see it as something to run away from. The information regulator is not just there to manage your compliance as a business, but also there to help you and to work with you on it. Minister, thank you so much for your time. I know you were traveling and you really gave us great insights. We really appreciate it. We hope we can chat to you again, maybe on the Cyber Act. And Savannah, thank you so much. Thank you for being a long-standing partner with the PBF. PBF subscribers, so if you don't know, as a benefit, BizHits is there for you to access if you have any questions or queries or consultation. They do allow for a free 30-minute consultation if you have queries on your business. So please make use of it through the PBF. Today was a very insightful talk. I hope it's been a great help to you as a business. We would love to have some insights from you, how you feel about it, how you feel as a business. Popia can help you. And if you feel there are any hindrances or you would like to participate a bit more in the sense of creating those guidelines, That's it for today. We look forward to seeing you again soon at our next masterclass and our next ministerial briefing. Thank you, everybody. Have a great weekend and afternoon.
Thanks very much.
Thank you.
Thank you very much, Sasha.
Thank you.